The Committee on Military Veterans and Homeland Security will come to order. Good afternoon, Mr. Clerk. Would you mind taking attendance, please?
Chair LaFave.
Here.
Representatives Beeler.
Here.
Eisen.
Here.
Bazat.
Here.
Martin. Jones.
Present.
Coleman.
Here.
Rogers.
Here.
Steenland.
Here.
Mr. Chair, quorum of the committee is present.
Thank you, Mr. Chairman. And Representative Rogers has a special announcement for the committee.
Thank you, Chair LaFave. I'd like to recognize special guests, the Van Dyke family from Kalamazoo County. Thanks for joining us.
Thank you, Representative Rogers, and welcome to the committee. Representative Rogers, would you make a motion to adopt the June 15th committee meeting minutes?
So moved.
Is there any discussion or objection, committee members? Seeing none, the Rogers motion is approved. So we have one member that is not with us yet, but will be soon. So why don't we take testimony on from Mr. Tom Lambert from Michigan Open Carry is going to discuss to us transportation requirements for lawfully transporting weapons in the state of Michigan.
Point of order, Chair. Could you let us know which bill and which sponsor? I didn't see that in the email.
Yeah, as there is no bill or sponsor yet, this is just a concept.
Okay.
As of right now, we have one sponsor in mind. We're looking for a secondary sponsor.
Thank you for the clarification. I appreciate it.
Thank you, Mr. Chairman, members of the committee, for your time today. My name is Tom Lambert. I'm the Legislative Director for Michigan Open Carry. I have been in front of you numerous times by now. Hopefully, you can ask me any questions. I'd be very happy to answer whatever questions you may have. Today is about the transportation requirements of firearms in Michigan. The main point is that long guns and pistols are not treated the same, and that is creating a considerable amount of confusion both among gun owners and law enforcement. In general, in order to lawfully transport a pistol, and first, Michigan Open Carry is particularly concerned about this issue, as most of the people that pay attention to this issue are people that have not yet obtained a concealed pistol license. As many people that carry or transport a firearm do have a CPL, that's why many members of law enforcement and the public don't pay attention to this distinction, and often inadvertently, with zero bad intent, end up on the wrong side of the law. Therefore, we urge the legislature to look at clarifying the language and aligning the criteria between pistols and long guns. To lawfully transport a pistol in the state, effectively, you have to have the pistol unloaded and meet all of the criteria in the law. That is unloaded, and in a case for the storage of firearms, the case must be designed for the storage of firearms. Technicalities matter here, and these technicalities do lead to prosecutions. It must be in the trunk of the vehicle, and only if the vehicle does not have a trunk is the option of having it in the cabin but not readily accessible to the occupants of the vehicle.
And for the benefit of members, if you want to follow along with this particular portion of testimony, you can flip to page 3 of the draft, starting on line 26 and then continuing on to page 4.
Yep. So you see on line 21 through 29, you see D and E, which are struck out. D is for a trunk. E is for vehicles that don't have a trunk. Again, E only applies to vehicles that do not have a trunk. The only time it can be in the cabin is if you're in a vehicle that doesn't have a trunk, and it must be not readily accessible. So, unloaded, in a case designed for the storage of firearms, in the trunk, or if no trunk, not readily accessible. All criteria must be met to a T. Long guns, for reference, Mr. Chair, I believe.
Page 2, line 17, pretend as though instead of it saying pistol, it says long gun, though.
Yep. Thank you, Mr. Chair. Instead of being unloaded and all of the following, long guns in the state are unloaded and one of the following. That's where that confusion comes in. Specifically as well because the options available don't necessarily line up. There's considerable overlap. I think the intent is to have them be effectively the same, but because the technicalities matter, there are gaps between the two, and we have had many people follow the wrong one with the wrong firearm, and it has led to trouble.
And a violation of this statute, what are the criminal penalties for that?
Mr. Chairman, the criminal penalty is a 5-year felony. There is no middle ground here, and there are absolutely jurisdictions, whether you are otherwise a completely law-abiding citizen, want that felony for ideological reasons. And I believe the proposal here also makes it a misdemeanor for the first offense. I'll get to that in just a second. So you see, the criteria for a long gun, which this bill would align the two different lists, if you will, is unloaded and taken down, or enclosed in a case, or carried in the trunk of the vehicle, or inaccessible from the interior of the vehicle. Again, unloaded is always required regardless of the set. And just to help you, unloaded in this state for these purposes means that no round is in the chamber of the firearm, and if the magazine is inserted in the firearm, there is no ammunition in the magazine either. It's not a loaded magazine in the firearm can be easily charged and ready to go. That's not what unloaded means. No ammunition in the firearm at all. One example, well, we have many examples, but one specific example was we had a recent veteran that served this country honorably, returned, decorated from the military, moved his family back to Detroit, had a scholarship to medical school, wanted to become a nurse. He had all of his belongings in the family vehicle, and the family vehicle was out on the road. An unrelated incident that had absolutely nothing to do with his family. Police showed up, asked his wife if they could search the vehicle. They had absolutely nothing to hide, so they consented to searching the vehicle. The police found a pistol in the vehicle that was completely disassembled, and I'm just going to say completely inaccessible from any occupants of the vehicle. It would have taken hours to unload the car, because it did take hours to search the car, to get to the components of the firearm. There was no ammunition in the vehicle. There wasn't even a magazine in the vehicle. He was charged with a 5-year felony and convicted of that 5-year felony. He lost his scholarships to medical school and everything that went with it. Another example we've had was a video of individuals unloading their pistol, storing it in the trunk of their vehicle, but because the video did not specifically show them storing it in a case designed for the storage of firearms, there's ambiguity as to the case. That individual was convicted of a 5-year felony. Even though they unloaded their pistol, put it in the trunk of the vehicle where it was absolutely not accessible to them from the interior, because they could not prove they met all the technicalities, they were convicted of that 5-year felony. Again, we receive many, many questions on this all the time, whether somebody's just trying to lawfully transport their pistol, whether they're waiting for their appointment to get their concealed pistol license, whether they just haven't gotten it yet. Same thing from law enforcement. What are the differences? Where do they align? What are the problems? And in addition to that, the bill seeks, or the proposal, if you will, seeks to make a first violation a misdemeanor. People make mistakes. Michigan firearm law is complex. I hope if I've conferred anything to you in the times I've been in front of you, it is complex. People with good intent do make innocent mistakes. This would allow somebody who is otherwise in compliance with the law, somebody who is not prohibited from possessing firearms, somebody who is not trying to do something wrong, who truly just made that innocent mistake, it would provide for a lesser punishment and an opportunity for them to learn from their mistakes and then comply with the law in the future, rather than denying them of their right completely. Mr. Chairman, with that, I'm happy to answer any questions.
Representative Rogers.
Thank you. It refers to the term taken down. Can you elaborate a little bit more about that?
Thank you for the question, Representative. There are many, many areas of Michigan firearm law that are gray. Unlike real estate law, unlike property law, which has been around for centuries and is well litigated, there is no defined definition of taken down. We generally interpret that to mean, and authorities that, secondary authorities such as the Michigan State Police, without looking to a court decision, generally mean the firearm is taken down where it is not operable in its current condition. So if you have a pistol, for example, in the example I mentioned before, the slide is pulled off of the frame where the firearm cannot operate in that condition. Many rifles are designed to be taken apart into multiple pieces. That would be taken down.
Vice Chair Beeler.
Thank you, Mr. Chair. You mentioned a little bit about the stipulation when a car doesn't have a trunk and therefore can't meet that requirement. Can you elaborate a little bit more about what we've seen in the past has been, I guess, determined to be inaccessible in those cases, and perhaps if this bill doesn't touch on it, if there's a solution there that needs to be made in order to clarify?
Representative, again, thank you for the question. That is a fantastic follow-up question to Representative Rogers' question. There is another area of tremendous ambiguity. What does inaccessible mean, or not readily accessible? It depends to a jury. I would argue that is a significant problem, as it is a 5-year felony that's on the line. We should provide more clarity there. I can tell you that I know specific examples. One specific example is a truck driver who had a firearm under his seat, in case follow everything else. It was under his driver's seat, and the truck driver was obese to the extent that I promise you there was no way he was getting to his firearm without stopping and exiting the vehicle. He was convicted of this felony because it was determined that it was at least readily, it was not readily accessible. I apologize for the double negative there. I know of another specific example that I consulted on with the attorney, where the gentleman had a pistol in a case, met all the criteria. It was underneath the passenger seat of his vehicle, and the seat was in the vehicle, attached to the vehicle in such a manner that there was no way he was going to get to it without stopping the vehicle, exiting the vehicle to the passenger rear door, and sliding the case out from there, and he was also convicted because it was, again, not readily accessible.
And just following up, is there any ambiguity in case specifically made for a gun? Because it seems like, is that a brand, right? Is it a brand name that we're looking for? Is it a style of carrying mechanism? I'm trying to, I guess, flesh out where the ambiguity is, and therefore where there could be perhaps a legislative solution.
Representatives, you're all tracking very well as to the problems gun owners face. And it's to be clear, it's not manufactured for the storage of firearms, it's designed for the storage of firearms. So if I buy something that isn't inherently for firearms and I modify it to store firearms myself, does that qualify? Arguably yes, arguably no. It depends on the jury and the prosecutors and the police in that case. What exactly is that definition? We have no clear line. We tell people that it's the case you purchased the firearm in. Most attorneys say that they can defend that if you walked out of the gun store with that case, you should, although you can never guarantee anything, be able to defend that. Short of that, I can't provide you a more specific answer.
Thank you, Mr. Chair.
So, Tom, I want to walk through a list of hypothetical examples. And Representative Eisen wants to do something first.
Thank you, Mr. Chair. That is a fine answer, walk out of the store with that particular case. But in a case of certain firearms where, like example, a Lambert 1911, you walk out of the store in a cardboard box, okay? And that cardboard box is not deemed a adequate, so you would have to purchase a aftermarket case for that. So that argument, I got a couple bears. They all come in a cardboard box, and it doesn't lock. It just, you open it up, you take it out of the cardboard box, and then if I transfer it, I have to do it in another case. So just clear that up. Some don't come in an adequate carry case, I guess. So
Representative,
I just want to listen.
Through listening to you from other committee meetings, I know you're very in tune with the troubles of Michigan gun owners. You're absolutely right. If I were representing that person and were I an attorney, I would argue that the firearm came in that. It came from the manufacturer in that case. It was built and designed, literally designed to handle that firearm. But just as you've described, that doesn't stop a prosecution, and that does not stop a guilty verdict due to the ambiguity of the law.
So when we're talking about lawful transportation of firearms, there's essentially 3 ways to do it. You can either, well, I guess not 3 ways to do it. There's only two ways to do it for pistols and only one way to do it for long guns. So for, if an individual wishes to avoid the onerous requirements under this, they could, of course, get a concealed pistol license.
Yes, sir. And that would apply to pistols, but not long guns.
And so if an individual were to get a concealed pistol license, they are still required under this statute and proposed draft to transport the long guns stored, if you will.
Correct. Unloaded and one of the criteria.
So either disassembled, enclosed in a case, or in the trunk or otherwise inaccessible.
Yes, sir.
Okay. Let us return in just a moment. We are going to handle some committee business first. Not necessary, thank you. At this time, we are going to read from the right script. 1 second. At this time, I will entertain a motion to move, to report House Bill 4197 as amended to the floor. Vice Chair Beeler makes the motion. Mr. Clerk, please call the roll.
On the motion to report House Bill 4197 as amended, Chair LaFave.
Yes.
Representatives Beeler.
Yes.
Eisen.
Yes.
Bazat.
Yes.
Martin.
Yes.
Jones.
No.
Coleman.
No.
Rogers.
No.
Steenland.
No.
Mr. Chair, you have 5 yeas, 4 nays, no pass, the motion prevails.
The bill is reported as amended to the floor with recommendation that it pass. We will now entertain a motion to move House Bill 4593, which is the County Police Officer Protection Act, to the floor of the House of Representatives. Can I get a motion to move it to the floor? Representative Bazat makes the motion. Mr. Clerk, please call the roll.
On the motion to report House Bill 4539, Chair LaFave.
Yes.
Representatives Beeler.
Yes.
Eisen.
Yes.
Bazat.
Yes.
Martin.
Yes.
Jones.
No.
Coleman.
No.
Rogers.
No.
Steenland.
No.
Mr. Chair, you have 5 yeas, 4 nays, no pass, the motion prevails.
House Bill 4539 is reported to the floor with recommendation that the bill pass. Thank you, members. That will conclude votes for today. There are no absent members. We will proceed now with the rest of testimony. And if any questions occur, please just let me know at any time.
Mr. Chair, I do have one more comment. The questions asked by the committee members about certain things and where does the line exist, and I've told you I can't answer that line. One way of addressing where that line is to come up with very precise language that would probably increase the length of the law to a considerable degree. Another approach to addressing the problem is to create alternatives and lessen the punishment should a mistake be made. So for example here, no longer would the technicalities of all the elements matter if you satisfy more than one element or one option. For example, it's unloaded, encased, and in the trunk. Well, is your case designed for the storage of firearms? Is it truly encased? What does encased mean? Well, you know what? It doesn't matter because it's in the trunk. And even when we get to all the end of that, if we still go through the technicalities of all the options, a mistake is a misdemeanor, no longer is it a felony for those truly with lawful intent.
And members, the draft legislation before you clearly denotes that a second offense of this, a technical violation of this offense would be a 5-year felony. So it's not as though you're going to be able to, we would be allowing criminals to blatantly violate this statute over and over and over again. It would be a one-time criminal justice reform, and then after that, you will be treated as a subsequent offender and subject to a 5-year felony. Mr. Lambert, I just want to go through the elements of transporting a pistol as it currently exists under law. So hypothetically, an individual has the pistol, it's unloaded, in a case but not closed. That case is designed for the storage of firearms, and it's in the trunk. What happens to that individual if a prosecutor wanted to?
Mr. Chairman, I would say that that meets the literal law because it is in a case designed for the storage of firearms. It doesn't, the law as it stands today does not say encased in a case designed for the
My
storage of
reading says it
firearms.
says is unloaded in a closed case.
A closed case.
three
I'm
last
getting
line.
rusty on remembering the exact words.
Last line.
Unloaded in a closed case. So if it is in the case and the case is not closed, then they have met all of the elements but that and are subject to a 5-year felony.
And if, as we mentioned before, if that case is not designed for the storage of a firearm, same 5-year problem.
Yes, sir. If the case has a latching mechanism and the case is closed, but that latching mechanism is not engaged, we have another gray area as to whether or not that case is truly enclosed.
We have a question, another question from a committee member, but I don't know which one. Go ahead, Representative.
Thank you, Mr. Chair. I'm just curious as to, there's no indication for like cable locks, trigger locks, you know, that makes a gun inaccessible to use. You know, if you put a cable through the slide, lock it, it's got a key. I would think that should be somewhat of an important part too, as part of making it inaccessible to work, trigger lock, stuff like that. But I don't see anything on, maybe.
I would just say to that point, Representative, the word inaccessible, it doesn't mean the word. Let's put it this way:
Usable.
if I took a firearm and put it in a cylinder and poured concrete into that cylinder, under the statute, that firearm is still accessible. So it does not meet the inaccessible element of the statute. It may not be readily accessible. It may not be easily to get to, but with a sledgehammer and enough time, I can access that weapon. So when the word inaccessible is used, trigger locks, taking it apart, removing all the springs, ammunition 4 miles away, doesn't fix inaccessible. Readily accessible may be better, would work with a trigger lock, absolutely. My concrete poured situation, it's not readily accessible unless you got a pickaxe and a sledgehammer, but
Mr. Chair, if I may, in this specific case, we do have case law that a pistol that has been rendered inoperable does not matter. Nowhere in the statute is operable mentioned, and therefore, even if your firearm is inoperable, you're still subject to the prohibitions. The ultimate goal here, Representative Eisen, is to align the criteria. I would defer to the committee and have no objections if the committee considers other acceptable options.
That was my point, is that you can, besides this, there's other ways of making that gun inoperable that should be considered. That's my point. So, thank you.
are there any further questions, members?
If I may, perhaps members of law enforcement might have other ideas as to options agreeable to them. Again, when it comes to agreeable options, we do not object to adding any further options.
I will say I'm very interested in this piece of criminal justice reform. As I'm sure most of you know, I'm a member from the Upper Peninsula of Michigan, and a couple of years ago I was pulled over by a tribal officer in Menominee. I was breaking law, I was speeding. So the tribal officer comes up to the window, and I do have a concealed pistol license. And he asked me how my day was going, asked me for license, registration, proof of insurance. I said, "Officer, I'm legally required to inform you that I have a concealed pistol license." And I go to hand him that, because I'm required to under the statute. He blocks the permit from entering his field of vision, shoves it back into the car. He goes, "I don't want to see that. If it's expired, that's 5 years in prison, and nobody has time for that. Are you a felon?" "No, sir." "Good. You should have a gun." Now, speeding's another problem. Let's work on that now. That's how it's handled in northern Michigan and the Upper Peninsula. Most of the time, if a technical violation of this statute occurs, either law enforcement or prosecutors and judges will do the discretion to the best of their ability. But if a state trooper sees a felony in the state, they can't just ignore that. And so The tribal officer's way of getting around that was to not see the license to find out if it was expired or not. But in other areas of our state, it is the opinion of the chair that that discretion from prosecutors and from the judicial branch is not happening. And it leads to discrepancies with incarceration. And I think that we should address that in a way that does not impact public safety. And I think that this may be a way to do that, and that is the only goal of this committee, is to make it easier for people to follow the law, know what law they have to follow, and if a minor technical in nature mistake happens, that it is not a life-changing forever mistake. Because I do believe in rehabilitation. I do believe in people getting their life back after they make a mistake. And I hope in the next coming weeks we can consider this and other forms of changes to the statute that make living life just a little bit easier in the state of Michigan for those who want to protect themselves, protect their family in the state of Michigan, as is outlined by Article 1, Section 6 of the Michigan Constitution. Are there any other comments from committee members, or are you guys ready for summer in-district work period? Seeing none, it's been an honor and a privilege to chair this committee. I hope that I get to continue in the next 18 months, but who knows? Thank you, members, for your time, and enjoy the rest of your week. We are adjourned.
Thank you for your time.